Start. Learned counsel for the petitioner raised several issues and contended that the principles of natural justice was violated with impunity, which caused prejudice to the petitioner, and therefore the impugned order stood vacated. The learned counsel submitted that a show cause notice was issued for the incident, which occurred on 16th 9th 2007, whereas the petitioner has been explained taking into account his previous conduct and taking into account the intelligence report of which the petitioner was not put to notice nor an opportunity to rebut the allegations made in intelligence report was given. The non-supply of the intelligence report, and by not providing an opportunity to rebut these documents, seriously prejudiced the petitioner, which was in gross violation of the principles of natural justice. The learned counsel further submitted that the intelligence report, which was relied upon by the disciplinary committee, was not signed by any person and had been prepared subsequently, and therefore cognizance on this report could be taken into consideration by the disciplinary committee. The learned counsel further submitted that the circle officer had certified that the petitioner was not violated in the of the university, and that the petitioner was given a clean chit and was absolved from the incident, which unfortunately had been discarded by the disciplinary committee without assessing any valid reason. The learned counsel for the petitioner further submitted that the resolution of the executive council was also liable to be accused, as it suffered from various infirmities. The learned counsel submitted that the quorum of the executive council was incomplete, and therefore the resolution of the executive council stood vacated on account of the mandatory non-compliance of having a proper quorum from holding a meeting. Further, the Vice Chancellor not only chaired the meeting of the Executive Council but also participated in the deliberations and voted for the resolution, which action of the Vice Chancellor was totally legal science. It was his own order which was cancelled in the appeal. The learned counsel for the petitioner submitted that the Vice Chancellor could not be a judge of his own cause, and therefore the resolution of the Executive Council stood vacated on account of